Hello, Carla Hartley here. I'm continuing our discussion of exit strategies in this video. And today I'm going to be talking about exit strategies for a spouse or a support obligor who wants to decrease his or her eventual support award or a support order. The award generally runs to the other side. This is best approached from three directions. First, how to increase opposing party's income or her ability to earn. Second, how to gear down the marital standard of living. And third, how to decrease the supporting party's earned income. Again, I am not including a discussion of child support here. A lot of the principles are the same and can be transferred over, but the support of children depends on two primary factors: the parties' respective incomes and the custodial timeshare. As I've said before, you really should not, as a loving and responsible parent, manipulate your kids to their detriment to increase or decrease your support payment. There are other ways to accomplish that goal, and those ways do not harm your children. Let's talk about increasing opposing parties' ability to earn. Now, we're talking about this as an exit strategy, so obviously if she's not working, or if he's not working, you want to get that person back to work, but not necessarily in just a minimum wage job. If you're looking at this long term, and it might even save your marriage to get a spouse that's staying at home or feels that they're in a dead-end position or a dead-end job, get that person working, get them job training, find out what career they want to get into, get them some education. I'm not talking about going back to school for an interior designer or a basket weaving degree. I'm talking about getting that person to go back to school for something that has a likelihood of producing an income. A lot of times we've seen when we get people back to school, get them back to work, that the resultant increase in their self-esteem will cure a lot of the problems that we had in the relationship. So that also is kind of a side benefit that will decrease your support obligation and maybe prevent one altogether. Saving the marriage is something we should consider as a possibility for as long as possible. But you're unhappy, you've been looking at this as a deteriorating situation, or you're getting a hint that the other side is trying to do this. So you might want to, work on your exit strategy. So what if your other side has already started not working? That this is what they have decided to do, and this is how you've started to think that, maybe you're headed towards this cliff. Well, you can either go ahead right now and pull the trigger on this, but most people who are the supporting spouse are not ready to do that. They'll make excuses for their future acts, perhaps arguing that the person is depressed, just needs a break, all sorts of excuses we can make for our loved ones, and these excuses often run to our detriment. I want to throw this out here, though, that in this case, in the case of a long-term support obligation, if the other party has decided to stop working, they have effectively undertaken actions that, if you let this go on for a while, decreases the marital standard of living. Now, I discussed this in my previous video on how this is a tactic that many would-be supported spouses will undertake to increase their temporary support order, but it operates to their long-term detriment. If you want to see how decreasing the marital standard of living by not working to your potential in the years running up to separation can actually hurt the supported spouse, please see my prior video on that issue. I don't want to go into that and repeat that, not at length here. But as I discussed in that video, the marital standard of living is essentially a cap on the total allowed income of the supported spouse. The total allowed income includes income they get from support and income they are getting from employment. Now, we have a number of laws that are out there. We have a misperception in the population at large that, this person has a duty to support me in the lifestyle to which I'm accustomed. That no longer exists because we have countervailing law, which has recognized that both parties, the supported spouse and the supporting spouse, have the right to live at the marital standard of living. And these cases and the current state of the law recognizes that incomes that supported one house, or an income that supported one house, now having to support two houses is a financial stress for both parties. So keep that in mind when we're looking at the marital standard of living. The supported spouse also has the right to live at the marital standard of living. All right, so I've discussed the marital standard of living now in 2 separate videos. If you have further questions about that, you can certainly contact us or another attorney. Now, for wage employees, how do you decrease the marital standard of living if you're a wage employee? Well, many wage employees will find themselves working 2 jobs. This happens a lot of times. We will see a lot of people backed into the situation where the at-home spouse is complaining because they're not at home enough, and then when they're away working extra, they're complaining that they don't make enough money. So this puts you in a catch-22. You're working as hard as you can to make all the money that this person wants for their support, but now you're not at home enough to make your spouse happy. This is the kind of catch-22 that you should consider as a warning sign in starting to look at your exit strategy. If you have kids, quit that second job and be home and be more available to your kids. If you can, stop the overtime, because the overtime increases the marital standard of living. The second job increases the marital standard of living, which raises the cap at which, or for which, the supported party's income can be awarded. All right, so now the third item that I want to discuss with you is decreasing your earned income. Again, for wage employees, you can't just walk away from a good paying job. You can't. Then, because if you do, the court's going to say, hey, you had the ability to earn this and you deliberately walked away from that in order to avoid your support obligation. The court can order support based on the income that you were earning when you quit that job. So don't do that. For wage employees, if you had to work 2 jobs up to the date of separation, the court can't require you to continue to work more than 40 hours a week. You can stop the overtime, you can stop the second job for the most part. If your second job is a business, we're going to kind of discuss that later. Now, if we're talking about overtime, and we're talking about stocks, bonds, performance units, there are ways to trickle those in to the marital standard of living, or even to kind of keep them out of the marital standard of living. That's not going to apply to most people, and I'm not going to emphasize it in this video presentation, because frankly, some tools of the trade I should be able to keep to myself. However, I want you to know that this is a possibility. You don't need to be bringing the performance units, the stocks and the bonds, and all of that overtime into your home on a regular basis as part of your marital standard of living. There would be an argument that if you have been keeping it deliberately out, that perhaps you are deliberately depressing the marital standard of living. But that's a somewhat sophisticated argument, and many people don't know how to prove that up. So I've never had that proved up successfully against me. Now, for self-employed individuals, this is where it gets fun for me, and maybe a little bit stressful for you. So it's a truism that self-employed persons can, to an extent, control their net income. If you're running a business, the net income is where it's at. Let's take, for example, an import-export business. You're going to have probably large gross receipts, but you're going to have also a large cost of goods sold. And then you're going to have what you're paying employees for retirement, what you're paying for vacation benefits, health insurance benefits, stuff like that. Things that are within the purview of the business, with you as a managing and controlling business owner, are largely discretionary, and the court tends not to micromanage sound business decisions. Even sometimes mildly unsound business decisions that might have been very sound 2 years ago. So The biggest thing you can do if you're self-employed, again, is to control your net income in the years preceding divorce if you know it's coming. Now, if you don't know it's coming and you're blindsided, there are still things we can do. But I'm going to tell you, this is a very complicated and intricate dance, and it needs to be done with the help of counsel. I'm also going to tell you, you're a lot better off if you see this coming on the horizon if you get into experienced counsel and start working on this. Now, when I talk about experienced counsel, I'm not talking about your run-of-the-mill family law attorney that, is not particularly experienced with business, does not stay up on all the latest law and motion activity with what is available to you to manipulate this. You've got to be up on the law. You or your attorney's got to be up on the law. And this comes down to something that we often hear. Family law is the most rapidly changing area of law in the country, and California is leading the way in that. And we, as a firm here, are absolutely committed to staying current with all of the developing cases that might affect our clients' rights, but particularly I am dedicated to staying current in the business area, and so is one of my associates. So we want to make sure that that's out there. Many attorneys don't know how to do this or would be afraid that they're going to lead their clients into a breach of fiduciary duty. It's threading a needle. You can't breach fiduciary duty because that'll cost you too much money. But you also don't want to be an idiot. I'm sorry, that's an overstatement. You don't want to be naive and not well advised in how you're going to approach the management of your business in the period coming up to filing for dissolution or in the period of time after dissolution's been filed and before judgment. I will say that you have to be part of the dance, and you have got to be the decision maker on the different options that we provide to you. So I think I have given you a good discussion of some of the exit strategies and the things you need to consider when you're headed towards a dissolution of marriage. I hope this will prompt you to look at the long-term consequences and not just short-term gain. Most people who come through our office and who go through the courts at the ends of these relationships have not given sufficient thought to the long-term planning and the long-term consequences of the positions they are going to take and the actions they're going to take. Generally, those who do have a significant advantage in the early stages of a case, and often we can carry that through all the way to a very successful and advantageous conclusion for our clients. I hope this has been helpful. Thank you, and have a very good day.